Jamie Raskin didn't just speak, he detonated the quiet in that hearing room. The moment he opened his mouth, everything shifted. There was no warm-up, no careful build, no political pleasantries. He went straight to the heart of the controversy, straight to the moment that millions of Americans had already watched on video, and straight to the inconsistencies that officials hoped people wouldn't question. And what he said in the very first sentence locked everyone in. Because according to him, the narrative being pushed about the Minneapolis ICE shooting wasn't just incomplete, it might be fundamentally wrong.
Just as much reprove the Attorney General and the President for going out and claiming this was self-defense without a complete investigation, especially when all the evidence of our senses would suggest if we're going to jump to a conclusion, we should jump to a conclusion that this was murder and not self-defense. But that's why we have the law. That's why we have a legal process. Now, the gentleman correctly states the situation, except he aborts the analysis midway. He says, well, she was told to stop, she was told not to go anywhere, but still she drove her car away. And I certainly saw that. The Supreme Court has a decision just on this point, which I'm sure the gentleman knows. It was decided in 1985. Everybody in criminal procedure learns it. Tennessee versus Garner, 1985, because Tennessee had a statute which said if there is someone fleeing the police, they can be shot. And the Supreme Court said that's not the rule. They can only be shot if they're fleeing the police if the police have probable cause to believe that the suspect poses a significant threat of death or danger to other people. Now, Ms. Good, who's a 37-year-old mom of a 6-year-old boy, now orphaned by ICE, posed no threat to anybody. At least, as far as we can tell, there's no suggestion that she posed a reasonable threat to anybody. That's the legal question. Now, I think our committee should launch an investigation into this. This would be a worthwhile subject for us to get into at this point. But the idea that simply because she disobeyed an order that she can be shot in the face at point blank is wrong. That's not the law in the United States of America. And you know who knows that? Everybody on this side of the aisle who talks about Ashley Babbitt. Because everybody talking about Ashley Babbitt seems to think that, well, she was told repeatedly to turn around and to leave, and then she still tried to use violence to get into our chamber, into the speaker's lobby in order to get at us. And she was shot and repelled. And there were 2 different investigations which found that that was reasonable force used by the police because she was coming at them. But what we had in this case was this woman was trying to leave. She was trying to get away from it. She wasn't coming at the police. She was trying to get away from the police. So to the extent that we want to engage in an immediate post-mortem analysis, and I agree with the gentleman that this is why we have law. This is why we have a real legal investigation, and it is completely irresponsible for the president and the attorney general to be out there claiming against all evidence that this was self-defense. This is why we have law. Okay, then we should wait until we can make a final pronouncement upon that. But let's at least get down what the law is. This is the House Judiciary Committee. And people cannot be shot in the face simply because they walk away from a police officer. And especially when we've got police officers who are masked. And I just want to finish on this point, and I'm happy to yield to my friend. Because look, all of us represent jurisdictions. We've got local police, we've got county police, we've got state police. None of them are masked. We've got the Army, we've got the Navy, we've got the Marines. None of them are masked. We've got the National Guard. None of them are masked. Why is ICE masked? This is what we want to know. Nobody's given us a good answer for this. Now, one suggestion comes from the fact that we have multiple January 6th defendants who are working at the Department of Justice itself, including Ed Martin and Jared Wise. So if they're hiring them at the Department of Justice, presumably they're hiring them at the Homeland Security and ICE, and maybe they don't want them to be identified because, of course, those people were very well video documented on the day of January 6th. There's a lot of suspicion that that's why these people are being masked, and they're not even telling us why they're being masked. But it's precisely this episode which demonstrates why people are afraid of ICE and will try to move away from ICE rather than submit to their order, even when people need to submit to a lawful order of the police. Happy to yield to the gentleman.
Well, and just in terms of the masks, I think it goes without saying that there is an element of undue danger when you deal with international criminals. But in regards to the facts of this case, is it not relevant the angle from the officer's perspective? The only angles I've seen have been from hindsight, where the officer was who pulled the trigger, and I'll stipulate it was a tragedy. Is it relevant to see what he saw? He couldn't see that the wheels were turning, if they were. He couldn't see what where the trajectory was. He was right in front of the car that accelerated in his direction. Is that not a relevant consideration to the ranking member?
Well, of course it's a relevant consideration. Yeah, I mean, if it comes down to a legal question, all of that is completely relevant. But what the administration is saying cuts completely against what we're able to see with our own eyes. Thanks.
The time of the gentleman's expired. The gentleman.
He started with a line that felt like a match dropped into a dry forest. If it's wrong to prejudge something as murder, then it's equally wrong and equally reckless to prejudge it as self-defense. That opening was cold, precise, and undeniably intentional. It was the kind of statement that forces the room to freeze because it flips the debate entirely. And then he followed it up with something even more startling. Top officials had already gone out in front of cameras and declared this tragedy an act of self-protection. Long before investigators could gather complete evidence, long before witnesses could be interviewed, and long before experts could assess what actually happened in those seconds. For viewers, this was the moment the story exploded beyond a single headline. It wasn't just a disagreement about force, it wasn't just a tragic encounter, it had become something far bigger, a collision between what people saw with their own eyes and what the government insisted had happened. Raskin leaned into that contradiction with the kind of confidence that comes from knowing he had the law on his side. He didn't rely on emotion, and he didn't need theatrics. He went straight to a Supreme Court ruling that police officers across the country are trained on. Tennessee v. Garner, a case from 1985 that reshaped the entire concept of justified deadly force in America. And when he connected that decision to this incident, the room tightened. Because according to that ruling, an officer cannot use deadly force on a fleeing person unless there is probable cause to believe that person poses a significant immediate threat. Not a vague threat, not a future threat, not a perceived threat built on hypothetical danger, a significant immediate one. And then he put the facts side by side. A 37-year-old mother trying to leave, not accelerating into anyone, not attempting to run someone down, not presenting anything close to what the law requires for deadly force. A mother who lost her life in a moment that should have been measured, controlled, and far from lethal. A child left behind without a parent. A community left stunned. A country left confused. This wasn't just about tragedy, it was about legality. And Raskin was clear, early claims of self-defense didn't line up with the available evidence, and they didn't align with the standard the Supreme Court set nearly 40 years ago. But just as people were processing that, he shifted the focus to a question no one expected: why were the ICE agents masked? He went down the list with an almost surgical calm. Local police don't wear masks. County sheriffs don't wear masks. State police don't wear masks. State police don't wear masks. The military doesn't wear masks. Even in the most dangerous domestic operations, identification is considered essential. And yet here in a domestic neighborhood during an everyday enforcement action, the agents wore covered faces. He didn't accuse, he didn't claim, but he presented something that had already become a growing conversation online. Rumors not confirmed but circulating widely, suggesting that some federal employees connected to prior political controversies might now work in these agencies. Speculation that masks weren't just for tactical protection, but to conceal identities tied to past notorious events. Reports claiming some individuals involved in high-profile incidents had found employment in federal departments. Again unverified, but the lack of transparency only fueled the questions. Raskin didn't say those rumors were true. He didn't say they were false either. He did something more subtle. He pointed out that without answers, speculation will spread, and silence from officials leaves the public to fill in the gaps themselves. A masked force operating without clear justification creates fear, and fear creates misunderstanding. And misunderstanding, he argued, can lead to the exact kind of chaotic moment that ended a woman's life. But it wasn't a one-sided hearing. A representative from North Carolina pushed back with a different angle, one rooted not in video footage or speculation, but in perspective, literally. He questioned whether the officer who pulled the trigger could see what the public saw. Could he see if the wheels were turning? Could he see if the car was moving forward or backward? Could he determine the exact trajectory in a split second? Or did he perceive danger based on the position he was standing in, the stress of the moment, and the unpredictability of the situation? Split-second perception versus video replay, training versus instinct, fear versus reality. It was a clash between two worlds, the world of physical evidence and the world of human reaction under pressure. Raskin didn't deny that perception mattered, he acknowledged it directly. But then he returned to the core issue: perception cannot replace investigation. Perception cannot justify officials declaring a shooting self-defense before a legal process evaluates the facts. Perception cannot override the standards set by law, and perception certainly cannot be the basis of immediate national conclusions, especially when what millions saw online contradicted the narrative being pushed from podiums. This was the turning point. The pressure intensified. The credibility of official statements came under scrutiny, and the country found itself watching a debate that wasn't just legal or political, it was emotional, unsettling, and deeply revealing. Because the truth is, people don't trust what they don't understand, and they definitely don't trust a force that hides behind masks, especially when tragedies occur. The fear surrounding ICE didn't start with this incident. It had been building for years, shaped by stories of aggressive raids, secrecy, and a lack of transparency. When you combine that public fear with an officer-involved shooting, the questions become louder, the speculation becomes sharper, and the demand for answers becomes unavoidable. Raskin ended his statement with something powerful: the law exists to give clarity when emotion overwhelms judgment. Investigations exist to uncover truth when narratives collide. And oversight exists to hold institutions accountable when their actions result in irreversible loss. But he also warned implicitly that the damage from premature statements doesn't just fade once evidence emerges. When leaders rush to define a story before the facts are gathered, they create a narrative that shapes public perception long before the truth can surface. And once a narrative takes hold, especially one tied to tragedy, it becomes almost impossible to undo. The hearing didn't resolve anything. It didn't answer the biggest questions. It didn't close the divide between communities and the agencies policing them. If anything, it widened the gap, showing just how far apart the two sides are in their understanding of the incident. On one side, a mother trying to drive away. On the other, an officer claiming imminent danger. In between, a country trying to figure out which version reflects reality. But what the hearing did accomplish was something far more important. It pushed the conversation into the light. It exposed the contradictions, the missing information, the conflicting accounts, the legal tensions, and the emotional scars. It forced the country to look directly at a moment that some hoped would disappear beneath official statements. And the deeper people looked, the harder it became to accept the early narrative. What began as a single traffic encounter has turned into a national conversation about deadly force, masked agents, premature judgments, and the fragile balance between authority and accountability. It exposed how quickly narratives form, how deeply they stick, and how dangerous they can be when they mislead a nation. This hearing marks the beginning of something far larger than one case. It marks a shift, a moment when lawmakers demand clarity, when the public demands answers, and when vague explanations are no longer enough. And whatever the investigation ultimately reveals, this case will shape how American law enforcement is judged for years to come. If you found this breakdown eye-opening and want to stay ahead of the stories others hesitate to dig into, don't forget to subscribe, like this video, and turn on notifications. There's more coming, and you won't want to miss what gets uncovered next.